Joining us on the line is Misty Marris. Misty's a trial attorney based in New York, specializing in the defense of clients in entertainment, sports, employment, civil rights, and sexual assault and abuse cases. She, of course, was covering the Chauvin trial gavel to gavel for HLN. Misty Marris, thanks for joining the show. Appreciate it.
Thank you, Ben, for having me. I appreciate being here.
First, let's talk, obviously, about the actual verdict. So the verdict came down incredibly fast. As soon as they said that it was coming down yesterday afternoon, I immediately said guilty on all counts because there was no way it was going to be anything else, obviously. You require a unanimous verdict for either acquittal or for conviction in Minnesota. There was no way they were going to acquit on all charges inside of 10 hours. That was just not going to happen. And if there had been any sort of debate, it would have gone to the judge. The judge would have told them to go back to chambers. What is your reaction to the verdict coming back this fast after a 3-week trial?
Ben, I was actually so surprised that the verdict came in. I wasn't even prepared, and I was on verdict watch. Thought to myself, this is crazy. I assumed that we would hear some questions from the jury. Very often, you hear the jury, they want the trial instructions, the jury instructions explained. They need a little bit more information, more context. Without one question from the jury, I was really surprised because, look, this case had a lot of complicated issues, specifically the medical testimony, the causation issue. 10 hours seemed incredibly fast, but my gut was the same as yours, Ben. When I heard that the verdict was in, I said, okay, guilty on all counts. Not what I had expected, but certainly once that speed factor with no questions, that was the result I anticipated under those circumstances.
So, Misty, frankly, I wasn't just stunned by the speed. Because it was so fast, it does, to me, raise questions about how seriously the evidence was considered in the case. Because I think that there was a fairly strong argument for manslaughter here, at least a decent to strong argument for manslaughter. I think that the case for beyond a reasonable doubt on third-degree murder is insane, frankly. I think that the elements of third-degree murder did not even fit to the extent that originally that was not included in the charging documents, and then eventually it was replaced. And the case for second-degree murder requires a bunch of barriers to be passed. The fact that there was no questions, it's just not a clear enough case for me to feel like the evidence was properly inspected by the jury. You can't get inside the jury room, but it does make me suspicious that the amount of outside pressure on this case must have had some impact in the thinking of the jury. Not that juries were intimidated, but that when you spend a year saying that this is the most important criminal case in modern American history, and then the jury comes back inside of 10 hours, hard for me to believe that they went in there, did an objective verification of the evidence, really went through each piece and examined it inside of 10 hours, and then came out with a conviction on all counts.
Yeah, 10 hours is incredibly fast for that reason, Ben. And yes, the evidence was incredibly complicated. I agree with you. You know, I really thought that we might see a hung jury on all counts, and that's because of that causation aspect. I thought that was really, really murky. And remember, the standard is beyond a reasonable doubt. The prosecution has to prove every element of every charge beyond a reasonable doubt. So to me, I thought that there was a strong possibility we would see a hung jury. I agree with you. I actually thought the prosecution's case, if you can get over that causation aspect on manslaughter, was pretty strong. We're talking about a recklessness standard that is a lower standard of as far as intent than the other charges require. For me, with respect to the other two charges, the murder charges, the highest level charges, there was evidence there that, look, at some point, this force was reasonable. Why do I know that? I know that because the prosecution's expert and the prosecution's witnesses said so. So to me, we're on a spectrum here, right? And now the jury is charged with determining, okay, the force was reasonable up until what point? And when does it become unreasonable to serve as the basis for these other charges? Now, when you're on that spectrum, it becomes incredibly difficult to get to that point where we say, oh, there was an intentional assault here, or there was a depraved heart. So I agree with you. You know, I thought those charges were a stretch, but look, the juries are unpredictable. I mean, we all know that. Anybody who covers trials knows that piece of it. And also, the jury can put more weight towards some evidence, more weight towards some testimony than others. And clearly here, my opinion, I think the video carried the day for this jury. However, you bring up another great point. There are so many appellate issues here that relate to what you said, whether or not this jury could be fair and impartial. Now, look, the defense had asked for relief on this front multiple times before and during the trial. First was asking for a change of venue. The basis for a change of venue is, can this defendant get a fair trial in this jurisdiction? Now, look, take the temperature of the area. You've got George Floyd Square. You've got the National Guard. The courthouse is on lockdown. you've got businesses boarded up. And you're talking about pulling a jury pool who's going to be impacted by this. These are members of this community. Their businesses, their homes, their lives could be seriously impacted. And that really needed to be part of the analysis of that change of venue. Court said no. They said, look, it's publicity everywhere. You're not going to be anywhere in the world and not know about this case. But that's really not where the inquiry ends, right? Because there's this other aspect about whether or not jurors are going to feel that they can come back with anything but guilty on all counts. So moving forward, the defense asked for the jurors to be sequestered a couple of times, once at the beginning and once when Daunte Wright unrest came out. Now, the court said no. I might have asked for a mistrial at that point, but that's just me, Ben. And of course, those issues are preserved on appeal. Right at the very beginning, during jury selection, a civil settlement of $27 million is announced in the midst of jury selection. 2 jurors who were already sat had to be dismissed because they were biased, or the court found that they could be biased due to that settlement. And then, of course, more recently, we have what happened with Maxine Waters, a member of the executive branch, saying that a murder conviction is the right conviction, and otherwise there's going to be consequences, essentially, that you get confrontational. I understand why Eric Nelson went in there and said, I'm moving for a mistrial under these circumstances, because it's becoming incredibly evident that there are outside factors that could be impacting what happens inside the courtroom. Now, the judge said no, but he did say, and this is the saltiest I saw Cahill in this whole case, he was very upset by the comments that were happening outside of the courtroom from government officials, Maxine Waters, presumably later Joe Biden, regarding this trial, because public opinion should have nothing to do with a jury verdict. The jurors are supposed to be fair and unbiased in that jury room, deliberating on the evidence that they saw in the courtroom and nothing more.
You know, Misty, many prominent public officials have come out since the verdict and have openly said, if we didn't have millions of people in the street, we don't reach this verdict, which to me is like game over as to your entire argument about bias in the criminal justice system. Your entire argument is the criminal justice system is corrupt and terrible, and that in this case they got it right. But the only reason that they got it right in this case is because we had people out in the streets. That is the definition of how the criminal justice system is supposed to not work, is that they're not supposed to care about there's millions of people in the streets for any cause. It's supposed to be about the evidence in this particular case for this individual defendant.
Correct. And I'm a defense lawyer, Ben. So I take that to heart. Our criminal justice system is based on a defendant getting a fair trial. It's based on the presumption of innocence. It's based on the prosecution's burden to prove their case beyond a reasonable doubt. It's not public opinion. The notion that public opinion, it's supposed to be a positive, that public opinion sways a jury, is actually terrifying to me. Because again, what you need is for fair trials. Every defendant needs to be treated the same, get a fair trial when they're in that courtroom. And the decision by a jury that takes their oath seriously, needs to be based on the evidence that comes into that courtroom, the elements of the case, the prosecution's burden to prove beyond a reasonable doubt. And again, Ben, I have to say it one more time, because again, this hits me close to home as a defense lawyer. Presumption of innocence. That is the cornerstone of our legal system.
Misty, let me ask about the appeals process here. So there would be great irony in Chauvin being convicted on all charges only to have the trial declared a mistrial because Maxine Waters decided to jet set into Minneapolis and ratchet up the tensions. How does the appeals process work? What are the prospects that something actually happens here, given the intense public pressure surrounding the case? It's very difficult for me to imagine that an appellate court simply decides to declare a mistrial after the most celebrated criminal justice case in modern American history, and after you have full-scale open celebration by the president and vice president of the United States of the verdict.
Yeah, no, and look, Ben, it goes up into the appeals court in Minnesota. So, there's certainly an element of it that's going to be, it's in that venue, it's in that jurisdiction. And appellate courts don't usually like to overturn trial verdicts. And that's on any case. So you make some really good points. If they're doing their job, the public opinion is not a part of the analysis. Look, I think the Maxine Waters comment, that threw oil on an already burning fire with respect to appellate issues. And they all have to be looked at in the totality, right? We can't just look at her comment and say, oh, poo-poo that. We have to look at it in the context of what the defense had requested to ensure that the defendant did get a fair trial and how that all played out what the judge decided and whether or not that is error, judicial error that can be overturned. Now, the analysis is based on whether or not the result would have been different, whether it would have had a meaningful impact on the ultimate result or the jury if something had been different, if one of these appellate issues is seen as error. So that's the standard. It's not an easy standard, but I would submit to you that there were other issues as well in this case, and they had to do with the scope of some of the testimony. Now, the bystander witnesses, again, the first question is, are these witnesses relevant? And look, they're bystanders. They're going to be relevant, right? It's relevant to the case. But the next question is, what about the scope of their testimony? Observations that they saw, okay. But these questions about how did that make you feel? I'm a New York lawyer. They say we're feisty. I would be doing jumping jacks in the courtroom.
Correct.
Objection. That has nothing to do with the case. And the analysis is probative value, which means facts that are going to lead to evidence or evidence that's going to lead to, facts in the case, or versus prejudice. So probative versus prejudice, and probative is supposed to be higher. Probative has to be more probative than prejudicial. And to ask these young kids, 17-year-olds, a 9-year-old, the clerk of the store, it was emotional. And the prosecution's case was largely emotional. And I would say it was impactful, certainly on television and probably to a jury. But I submit to you and our listeners, and if I'm drafting this appeal, I'm focused on the fact that that was just so far outside of the scope of what is relevant and so highly prejudicial that it would be error that needs to be revisited on appeal. And I just want to make it clear, I'm not saying the jury got it wrong. I personally don't feel that I'm in a position to say what's right or wrong, because again, public opinion, my opinion, that doesn't matter. But the cornerstone of our democracy, the cornerstone of our legal system is a fair trial. And all of these issues absolutely need to be addressed in the appeals process, and see where that goes. You've flagged some concerns. Again, if judges are doing what they're supposed to do, they are to look at this through the lens of what is correct under the legal standards without respect to what's going on in the public.
Well, that is Misty Marris. You can check her out. She's been doing Derek Chauvin trial coverage for HLN, and she, of course, is an attorney based in New York City. Misty, thanks so much for your analysis. Really appreciate it.
Thank you, Ben.
We're in a battle for the culture and for our values. Like and subscribe to help keep our videos on the front line of the fight and top of your feed.